On the 1st of October this year, the Sale of Land Act Section 32 vendor statement has had some changes come into effect. Most notably, the level of disclosure by the vendor is still there, but they've removed some of the items from the Sale of Land Act that were no longer relevant and required repeal. And the other items are about just bringing a greater level of disclosure and clarity to a vendor statement and ultimately to the consumer. One of the changes is that the Section 32 vendor statement no longer is required to be attached to the contract of sale. So the contract of sale and the vendor statement used to usually come together as one document. Now the vendor statement can be presented by the estate agent to a purchaser. It only needs to be signed by a vendor and not a purchaser. But out of habit, I think we will still continue with the good business practices that have evolved over the years, and that is still to require a purchaser to sign the Section 32, so at least all parties are aware that the purchaser has been given a copy of the document and that they have acknowledged that by signing and dating the Section 32. Some of the other changes relate to building insurance and the vendor's requirement to disclose the building insurance that they hold in place, where the contract provides for the risk to pass to the purchaser upon the date of contract. That's very rare that a property would pass, the risk would pass to the purchaser, but in the cases of buying from a mortgagee in possession, quite often you'll see a clause in there that they sell the title and anything else that is part of that property they make no warranty to. So you will need as a purchaser to obtain insurance immediately upon signing that contract or very soon after. Another change to the contract, to the Sale of Land Act, is that a title search must now be attached. Previously, it could just be a photocopy of an old title, but a title search shows you all of the encumbrances, such as caveats and such as owners' corporations registered on title. A photocopy of an original title won't necessarily show you those encumbrances on there. Another change is also with owner-builder warranty insurance, which if the owner-builder, it previously didn't sit in the Section 32, it would be a warranty under the general conditions in the contract, but now there is a requirement for the vendor to provide the details of the owner-builder warranty insurance for works above $16,000 that they've carried out themselves during their ownership. Those details are required either by way of attaching the certificate, the warranty certificate, or detailing it in the Section 32 itself. Finally, the services to the property, which is usually telephone, power, sewerage, gas and water, now must be disclosed if they're not connected. Previously it was connected or not connected. Now you only have to disclose what service is not connected to the property. There's been two slight changes to the prescribed contracts. The front page used to have the order of priority of the documents and how they were to be read as the particulars of sale, special condition, general conditions and vendor's statement in the order of that priority. Now the vendor's statement has been removed because it's no longer required to be attached to the contract of sale. So the order of priority is particulars of sale, any special conditions and general conditions.